Hello friends, welcome back to the series of lecture. This is the 49th lecture of this series of Indian Evidence Act. So in this lecture we would start with retracted confession, then we would see after that the exculpatory and inculpatory. Now you see whenever A makes a confession, so either you make the confession either the judicial or extrajudicial, that is out of the court. Now he had make the confession and now at the trial stage when he asked that did you make the confession, because the prosecution will prove the confession. In trial, the prosecution will prove the confession and A will be asked by the court, did you made the confession? खास करके जो 313 का एग्जामिनेशन होगा, 313 का एग्जामिनेशन CRPC, there he will be asked about the evidences. So he will be asked that do you made the confession? Now suppose the accused says that no, I did not, or he said that I made the confession but that was under compulsion. I did not make it voluntarily. The moment he retracts means what? Steps back. The moment he retracts, the same confession now will be called a retracted confession. उसी confession के आगे आप retracted word add कर दोगे, that becomes retracted confession. इसको लिख लीजिए आप, write down. When the accused, after once having made the confession, declares at the trial stage that the confession was not made by him or that the confession was made by him under compulsion, then such confession will be called a retracted confession. Now you see, suppose I am an accused and today I make a confession before you. Suppose I am an accused and today I make a confession before you. Now it is normally being expected that at the trial stage, it is normally that refusing at the trial stage. I will refuse at the trial stage, I will retract. Accused कहेगा नहीं नहीं, I did not make the confession, or he will say that it was obtained from me under compulsion, involuntarily. So in either of these cases, the question is whether the court, because of the question of the retraction, whether the court will, because of the retraction of the confession, whether the court will give up the confession as a piece of evidence simply because the accused has retracted, then will the court give up the confession as a piece of evidence, or will the court still admit the confession? अगर confession give up करोगे तो accused तो हर केस में retract कर जाएगा, तो confession तो useless हो गया फिर, because 99% cases में the accused will retract. Earlier तो out of conscience he made the confession, but later on when the trial etc starts, the lawyer engage हो जाएगा उस समय and the lawyer will tell him you must retract. So in every case almost the accused will retract. So then the confession will become a useless relevant fact, and therefore the court will not give up the confession merely because the accused has retracted. The court will examine as to on what grounds he is retracting. If he is saying that I am not administered, suppose if it was a judicial confession, he says that I am not given the warning that you are not bound to make the confession, etc., then the court will obviously summon the magistrate and examine the magistrate as to whether warning was given or not. The court will look at the record of the confession and then the court will infer as to whether he is retracting without any genuine reason, or actually there is a defect in the recording of the confession, or actually there was a defect in the recording of the confession. So that is where the court has to apply its judicial mind. अब आपने कह दिया कि मैंने कन्फेशन किया नहीं था और एक्स्ट्रा जुडिशियल कन्फेशन है, आपने तो कह दिया कि मैंने कन्फेशन किया नहीं था, और कन्फेशन कैसा है? एक्स्ट्रा जुडिशियल कन्फेशन. एंड द पर्सन टू whom you made the confession, he is giving testimony on oath that this person made the confession, and that person is cross-examined also, and despite cross-examination the witness is established. Then in that case the court will not trust you. Even if you are saying that I have not made the confession, हाँ, court may always ask the witness certain questions under 165 Evidence Act to assure itself whether the confession was actually made or not, and if it was actually made, if court was assured that it was actually made, then even if you are retracting, the court will not affected by that, and the confession will be admissible. Not even the evidentiary value of that confession will be affected. अगर retraction का fact disprove हो जाए, जिस ground पे तुम retract कर रहे हो वो ground admissible ना हो, तो फिर the confession is admissible as a normal confession and the evidentiary value will also not get affected. इसको भी लिख लीजिए आप, write down. Whenever the accused retracts from the confession, the court will always examine the truthfulness of the circumstances upon which the retraction is being made, and if the court is satisfied that the grounds of retraction is ingenuine, then the court will not allow the retraction, and the confession will be admissible as a piece of evidence. Court will not allow the retraction and the confession will be admissible as a piece of evidence. Here the court has to exercise its judicial mind and discretion. The confession will not lose its evidentiary value in such a case. अब ये जो point लिखवाया, that was held in these two cases. Bharat versus State of UP, 1974 Supreme Court, and another one is, this one is landmark judgment, Pyarelal versus State of Assam, 1957 Supreme Court. This is landmark on this point, what we have written. Pyarelal versus State of Assam, 1957 Supreme Court. मैं इसको रिपीट कर रहा हूँ एक बार कि retraction अगर आपने किया है, if you have retracted from the confession, so that is normal. Every accused will normally retract. That does not mean the confession will not be admissible. The court will examine in such cases as to whether the accused is retracting casually or he is having some substantive grounds to retract. And if you suggest that there are grounds to retract, for example, it was involuntary, etc., then the court will examine the magistrate or the person who has taken the confession, अगर extrajudicial confession है तो. And after the examination, if the court is satisfied that the confession is proper and the grounds of retractions are false, then the court will admit the confession as normal as the confession is, and even its evidentiary value not get affected. उसी तरीके से सेक्शन 30 में आप याद करो, को एक्यूज्ड का कन्फेशन होता है सेक्शन 30 में. इन सेक्शन 30 A has confessed and in which A has implicated B also. अब A ने कन्फेस किया and in the court A retracts. अब what will be the effect? You talk about the A, forget the B for the time being. The court will also the court will examine the same thing, whether the retraction is upon the genuine grounds or not. And if the court finds that the retraction was not upon the genuine ground, then the confession is admissible as normal as it is, and therefore will it loses its evidentiary value against A? Will it loses its evidentiary value against A? No. Against A? No. A ने कन्फेशन किया था और रिट्रैक्शन का जो ग्राउंड बताया है, those grounds are found to be false. So will the confession will be admissible and will it have the same evidentiary value? Answer is yes. So if it has the same evidentiary value against A, then it will have the same evidentiary value against B as it is provided in section 30. So it may be taken into consideration. So अगर accused ने retraction किया है, जिसने confession किया था, तो उसके retraction से co-accused के लिए जो confession किया था उस पर भी कोई फर्क नहीं पड़ेगा. अगर retraction admit नहीं होता, then the confession is admissible and therefore it can be used against co-accused as provided in section 30, and it can be used against main accused as well. So retraction अगर admit नहीं हुआ, confession admissible हो गया, in that case there is no effect upon the evidentiary value even with respect to the co-accused. इस sentence को भी लिख लीजिए. If retraction was discarded and the confession is admitted, then the evidentiary value of confession will not get affected with respect to main accused who made the confession or the co-accused who was implicated in the confession. तो ना तो मेन accused को फर्क पड़ेगा, ना ही co-accused पे फर्क पड़ेगा, and evidence will be as normal as it is admissible and reliable. तो यहाँ पे co-accused के लिए जैसे 30 में रहेगा, वैसे ही retraction के बाद भी उसकी एविडेंस की वैल्यू और रिलायबिलिटी रहेगी co-accused के लिए भी. अब now the next issue is suppose a statement made by a person. Suppose there is a statement made by the accused, and in that statement the accused make the exculpatory and as well as the inculpatory remarks. दोनों तरह के remarks हैं. अब exculpatory means what? Something which is going to favor him, something which is going to support the accused. And inculpatory means something which disfavor, something which goes against the accused, something which disfavored or something which goes against the accused. Now in the same statement he made both exculpatory and inculpatory remarks. Now can the court remove the exculpatory part and include only the inculpatory part and use it against him? The court can, if these two are separable, then the court can. अब एग्जाम्पल से समझते हैं. मान लो accused A ने एक कन्फेशन किया और कन्फेशन में he said that I shot upon B and due to which B died. So it is an incriminatory sentence or not? It is an incriminatory or inculpatory sentence. But at the same time the next sentence is I shot because B had first shot upon me. वो कह रहे हैं कि मैंने B पर गोली चलाई क्योंकि B ने पहले मुझ पर गोली चलाई थी. Is it not an exculpatory sentence? He is trying to take the plea of private defense. Now you see, एक तो कह रहा है कि I shot और दूसरा वो कह रहा है कि I was acting in private defense. Now this is the incriminatory part and this is the exculpatory part. Now how will the court act in such a case? Which part the court will admit? अगर दोनों को एडमिट करता है तो हौच पौच हो जाएगा, कंफ्यूज हो जाएगा. Then which part the court will admit? Now the point is, you see that in such cases the court will look at the other evidences. The court will look at the other circumstantial evidences and court will see which of them appears to be false. Now इसमें जैसे obviously I shot, वो तो true होगा because circumstantial evidences are there. अब the court will examine that does this private defense वाला part appears to be false from circumstantial evidences. अब जैसे अगर B ने गोली चलाई होगी तो कुछ तो मार्क होगा B के गोली का, दीवार में लगी हो और कहीं लगी हो किसी जगह. आई विटनेसेस होंगे, they will tell you that the B shot or not. अब B ने गोली चलाई होगी तो किसी हथियार से चलाई होगी. That should be recovered from B or somewhere else, which shows that B had shot from that pistol. उस पिस्टल पर उसके फिंगरप्रिंट्स के निशान होंगे. So there should be some evidences which suggest that there is a case of private defense, and if the court finds upon the examination of the other circumstantial evidences that there is no situation of private defense, then what will be the court do? The court will discard the exculpatory part. It will discard the exculpatory part and it will admit only the inculpatory part, provided they are severable. In this case, these are severable. These two sentences can be read separately. If that can be done, then the confession will be used against the accused. लेकिन अगर मान लो कोर्ट को दिखता है circumstances में that there was a situation of private defense, then the court cannot discard the private defense wala part. Then the court has to admit that also. If the court finds that there is a situation of private defense, then the private defense wala part of the statement cannot be discarded. That is the broad approach of the court. Whenever you make a statement, this is not only about the confession. मैंने confession का example दिया. It can be an admissional statement also. उसका example हम बाद में देखेंगे और उसके ऊपर केस भी है, उसको भी डिस्कस करेंगे. So whenever a confessional statement is made, and in that if the accused made an inculpatory statement, for example that I did the offense, but at the same time he raises some exception, so will the court discard the exception per se and admit the confessional part? Answer is no. The court will examine the circumstances and see whether the exception wala part, defense wala part, is untrue or not. If it is untrue, then the court will discard that and court will admit only the incriminating part. If it is not found to be untrue, means it is also found to be true, then both of them have to be admitted. So इस एग्जाम्पल में अगर प्राइवेट डिफेंस वाला पार्ट अनट्रू मान कोर्ट को फाइंड आउट होता अनट्रू है, तो इस वाले पार्ट को आई सॉट अपॉन भी इसको एडमिट कर लेगी कन्फेशन को, और अदर सर्कमस्टेंशियल एविडेंसेस होंगे तो उनको देखकर द कोर्ट विल कन्विक्ट द एक्यूज. और अगर कोर्ट को फाइंड आउट होता है दैट दिस पार्ट इज आल्सो ट्रू, then the court will admit both of part of this sentence and have to acquit the accused. Now write upon this topic. Whenever in a confession the accused has made both incriminating and exculpatory statements, the court cannot per se discard the exculpatory statement. The court cannot per se discard the exculpatory part and admit the incriminating part. Rather, it has to examine the truthfulness or falsehood of the exculpatory part in the light of the other circumstantial evidences, and if it is found to be false, then it can be discarded and the incriminating part shall be admissible alone. Otherwise, the entire statement has to be admissible. So this is what about confession. But the same rule will apply about the admissional statements also. अब जरूरी नहीं है कि accused may confess. Sometimes accused may also make some general statements. Sometimes he make a general statement which is admissional on some fact, but some fact of that statement is self-beneficial. उसने कुछ बयान दिया है कि जिसमें से कुछ पार्ट तो उसके खिलाफ यूज हो सकता है लेकिन कुछ पार्ट उसके फेवर में यूज हो सकता है. अब उसके केस में कोर्ट क्या करेगा? द कोर्ट विल एग्जामिन द सर्कमस्टेंसेस and the court will see as to whether the surrounding circumstantial evidences that exculpatory part is true or untrue. If it is untrue, then the court will use the incriminatory part against the accused. But if it is true, then the incriminating part alone cannot be used. Then both of them have to be admissible. Now there is a case upon this point. Please take down the name of the case. Nisikant Jha versus State of Bihar. Nisikant Jha versus State of Bihar, 1968 Supreme Court. There was 5 judges bench and judgment delivered by G.K. Mittal, Justice. अब इस केस के फैक्ट्स बता रहा हूँ मैं, ध्यान से सुनिएगा. These facts are we are discussing here to understand the topic. इसको एग्जाम में लिखने की जरूरत नहीं है, जो एग्जाम में लिखना होगा that points we would discuss later on and उस पर मैं लिखवा भी दूंगा. But it is good if you keep remember the facts of the cases, at least for the important point of that topic, those facts which is related to that topic. अब exact details अगर आपको पढ़नी है तो you can read it from the case, but for here the facts are that there was a train, एक passenger express train थी, which stopped to a station called माधवपुर. एक ट्रेन माधवपुर स्टेशन पर 3:52 पर रुकी, 3:52 PM on 12th of October 1961. It stopped. अब the door of the one of the compartment was locked from inside. From one side, from the platform side, the door of the one of the compartment was locked. So when they went from the other side, the door was open, the other side of the platform, and inside this train, inside this compartment, a dead body was found, whose throat had been slit, and near the lavatory, near the toilet, the dead body was found, and a lot of blood was found around it. Then the other door was opened and the dead body was taken out, etc., etc. अब within an hour, लगभग 5 बजे के आसपास, पौने 5 बजे के आसपास, जब सनसेट का टाइम होता है विंटर्स में, उस समय there was a river called river Patro. In that river, around the Madhavpur station only, a person was found washing his clothes and the other things, and he was totally soaked in the blood. This person was found to be totally soaked in the blood. सिर वगैरह पूरा सब खून से लथपथ था उसका, हाथ कपड़े everything was soaked in blood. He had got some books and the books were also soaked into the blood. There was another person who saw him washing his clothes, etc. He asked him कि what has had happened. उसने इससे पूछा कि क्या हुआ था, इतना खून कैसे लग गया, how much there is blood on you. So he replies, and this reply is the first statement that this accused made. He replies that I was coming from somewhere and some cowboy stopped me and tried to steal my money. He took away the money and with a piece of glass he cut my finger. मेरी उंगली काट दी उसने, मतलब काट के अलग नहीं हुआ, हल्का वो कट लगा उस पर उंगली पर, उसी वजह से इतना ज़्यादा ब्लड आया. अब दिस पर्सन वॉज सस्पिशियस कि उंगली कट गई तो इतना खून कैसे आ जाएगा, और सिर पर खून कैसे चला जाएगा, उंगली कटने के बाद तुमने सिर पर रख रखा था क्या हाथ, और फिर उस खून को बहने का इंतजार किया कि भाई सारा खून ऊपर से सिर से टप के नीचे था. सो इट इज़ नॉट पॉसिबल. So he was suspicious, but he went back to his village. When he reached the village, that witness, then he heard, when he reached to the village, he heard that a dead body was found in the train. And then he immediately becomes suspicious that the dead body was found in the train around the 4:15. And at 5:15, this person is washing his clothes, blood, etc. So this person told all these things to the Sarpanch and the other people of the village, and they asked him that where is that man. So the Sarpanch directed them to go and find the man. Now they went to the river, but he was not there. Then they went to search of them, and he was found to be moving in the bullock cart. So there he was stopped, and when he was asked that are you going, so he said that I was going to my sister's village. उसकी sister का गांव का नाम था रोशन. I am going to my sister's village. And then they caught him and brought him to the village. They took him to the Sarpanch, and Sarpanch asked them to take him to the Mukhiya. And there, before the Mukhiya, he make certain statement. Before Mukhiya, he made certain statements. So now you see the earlier statement made before the witness was what? सरपंच ने मुखिया के पास भेजा, मुखिया को उसने स्टेटमेंट दिया, पर पहला स्टेटमेंट किसको था? विटनेस को. इन विच ही सेड दैट काउ हैड स्टॉप्ड मी, और क्लास से कट कर दिया एक्सेट्रा. बट हियर ही चेंजेस हिज स्टेटमेंट. और नाउ हियर इट इज द फॉर्मल स्टेटमेंट मेड टू द मुखिया which has been formally recorded, and there he clearly says, अब स्टोरी सुनिएगा इसमें. There he clearly says, I was coming in the train. So in his second statement given to Mukhiya, he admit that. अब इस सेंटेंस पे ध्यान देना, क्योंकि इसी सेंटेंस को अभी हमको डिस्कस करना. पहला जो पॉइंट है वो ये कहता है that I was also in the train. I was in the first class compartment of the train, and in that train there was one more person along with me, but I did not know him. उसने बोला कि I did not know that other person. Other person is the victim. So accused says that I was in the same compartment, but I did not know the victim. Then he says that on some railway station, another person got into the train, and I knew him. A third person gets into the train. He says he knew him. अब accused का नाम आप A कर लो. Victim is B, and third person is C. So he says that I was traveling with B in the first class compartment, and this C got into the train on some railway station. Now when the train moves from that railway station, he closed all the windows and the door from inside. उसने सारी खिड़कियां दरवाजे अंदर से बंद कर दिए. And he also said that I knew C, और C का नाम भी बताया उसने. C का नाम बताया उसने लाल मोहन शर्मा. He said that I know him, he is लाल मोहन शर्मा, and who stays somewhere in देवगढ़. तो उसने C को आइडेंटिफाइड किया. Accused himself identified C, that he got into the train, and he locked the doors and windows from inside, and he took out a knife and dragged B towards the toilet lavatory, and there he started hitting him. There he started beating B, and finally I tried to stop him. जब वो B को मारने लग गया तो मैंने उसको रोकने की कोशिश की. उस पर उसने चाकू से he gave me a cut on my hand, and after that he threatened me, and I am out of fear. I sat on the one side of the compartment. Out of fear I sat on one side of the compartment, and thereafter he slit the throat of B and threw him near the toilet. And when the train was approaching near the Madhavpur station, he opened the door from the other side and jumped from the running train. Then I found that if I caught with the dead body in the compartment, then everyone will suspect me, and therefore I will also run from the jump. I also jump from the running train, and thereafter I was washing my clothes, etc., near the river, where I was seen by the witness. So this is the story what he tells. He had said that when he gave me a cut in my hand, I sat on one side of the compartment. अब इस पूरे स्टेटमेंट में एक्यूज्ड एक फैक्ट तो एडमिट कर रहा है. He was admitting a fact that I was there in the compartment with B. He is talking about C also, but is it not he admitting the fact that I was in the compartment with B? Plus he is also admitting that I know exactly that how the B was killed. Knife से throat slit किया गया etc. And he was thrown near the lavatory, and the dead body was exactly found near the lavatory. Means the fact admitted by him is that I was present in the same compartment with B, and also that I know exactly how B was killed. So this is what he has admitted. पहले उसने admit किया था कुछ और, cowboy and all that, but now this statement he has admitted. अब इसको भूल जाओ थोड़ी देर के लिए. अब other evidence that was found against him were: number one, he had lot of blood upon his body. Face and hand also had blood. All his books were soaked into blood. His belt was soaked into blood. And when he was arrested by the people of village, so the books were discovered from him, and a knife was also discovered from him, and that was a big knife. जब पकड़ा था लोगों ने इसको, जब उसकी तलाशी ली गई तो उस पर एक बड़ा चाकू भी मिला था और चाकू में भी ब्लड लगा हुआ था. Despite the fact that he has tried to wash, the chaku still has some traces of blood upon it. Despite the fact he had tried to wash everything, still some traces of blood was found on his bag, books, clothes, etc., knife. Now, one logical question is, if he is saying that cut on his hand and that cut was also found on finger. So if he is saying that the cut is on my hand, then how much blood from that cut release so that entire body, books, etc. is soaked into the blood. इतना blood तो नहीं आएगा. So that is one logical issue. So that was not the blood in his clothes, bag, books, etc. that was come out from his cut. It may be some else's blood. And the blood group found upon the knife's books, that blood matched to the blood of the victim. अगर उसका अपना ब्लड होता उसके कपड़ों वगैरह पे शरीर पर, तो दूसरे का ब्लड उसके ऊपर कैसे आया? And you are saying that in train when you had given a cut और उसका victim का गला बाद में काटा गया तुम्हारे कट देने के बाद, तो उसके पहले he was hitting him because according to A, she was hitting B first, and when A tried to save B, she gave a cut on his hand, and now he says that I went and sat into some other corner of the compartment under fear. So when he is sitting some another corner of the compartment, then how that person's blood come upon you? Because किसी का गला काटोगे तो obviously lot of blood comes out, but that blood is still around the body only, and you are saying that you are sitting somewhere else, then how that blood comes upon your body? So these are two facts very important. So finding of so much blood upon his body is unexplained, and दूसरा because that hand वाला cut cannot reveal that much of blood, and दूसरा the blood group that was found in your books, knife, clothes, that matches the blood group of the victim. And the other important fact was that this person was actually a student of class 10th. ये सब 10th क्लास के बच्चों की कहानी है, बट उस समय के 1961 में हुआ था इंसिडेंट, तो उस समय के 10th क्लास के बच्चे बड़े हुआ करते थे बिकॉज वो लेट पढ़ना स्टार्ट करते थे उस समय. तो ही वॉज अ स्टूडेंट ऑफ क्लास 10th. अब ही वॉज इन सम पर्टिकुलर स्ट्रीम, साइंस और आर्ट्स स्ट्रीम, and the other person who is a victim, he was also of the same school but of a different stream. Same class का था पर different stream था. And there is a football team in which both these people, accused and the victim, used to play together. तो जब आप साथ में फुटबॉल खेलते हो, एक ही टीम के हो, एक ही स्कूल के हो, और ख़ास करके जब आप साथ में फुटबॉल खेलते हो, so why did you tell that you did not know him? You cannot recognize him. हो सकता है तुम पहचान ना पाओ उसको, but you said that I did not know him. So again this is a false statement made by you regarding the identity of the person. Plus a knife was discovered from you. A knife is such which the doctor has opined. It is the knife which could have been used in the slitting of the throat. And you could not explain how that knife came to him. वो एक्सप्लेन नहीं कर पाया कि as to how that knife came to him, and therefore in this case the circumstances is going against him. Circumstantial evidences are clearly suggesting, and one more circumstances, that he gave the address of Lal Mohan Sharma, that he is residing in so and so place, so and so city. But when the police went to search for that Lal Mohan Sharma on that address, they searched everywhere, but there was no person of that name staying at that locality. Means he gave the fictitious name to the police. So that entire conduct of making false statement, of making that fictitious name, the washing of the blood, etc., the entire conduct suggests that he has conducted the crime, he has committed the crime. Now the chain of circumstantial evidence is not totally complete, but chain of circumstantial evidences is at least rejecting the exculpatory part. अब चेन ऑफ सर्कमस्टेंशियल एविडेंस पूरा कंप्लीट नहीं हो रहा, पर इतना तो कंप्लीट हो गया कि it is rejecting the exculpatory part. And what was the exculpatory part? What was the exculpatory part in the main statement? That I did not kill, Lal Mohan Sharma killed. That is the exculpatory part. और एविडेंस इससे दिख रहा है कि that he himself killed, and therefore the exculpatory part is rejected. And if the exculpatory part is rejected, then what remains? The inculpatory part. And what is there in the inculpatory part? That I was present in the train, and I know exactly that how he has been killed. So these two facts are admissions made by him. He had not confessed that I have killed, but these two facts are admissions by him, and that will be self-incriminating admissions because that go against him कि घटना के समय तुम भी ट्रेन में प्रेजेंट थे और तुम्हारे खिलाफ और भी एविडेंसेस हैं और साथ में इस बात का एडमिशन है कि तुम ट्रेन में विक्टिम के साथ थे. यू आर प्रेजेंट विद द विक्टिम इन द ट्रेन, सो दैट एडमिशन coupled with the other facts go on to complete the chain of circumstantial evidences, and therefore he will be convicted. फिर से सुनिएगा इसको ध्यान से. कल exculpatory part क्या था इसमें कि I have not killed, the Lal Mohan Sharma has killed, but that is found to be false, and therefore that part will be rejected. So that part can be separated from the incriminating part, and the incriminating part is what? That I was present in the train, and I know exactly that how the victim has been killed, and why he jumped outside the train from the other side, that everything was accepted by him. So these facts together are incriminating facts. They go together with the other evidences. The conduct of not identifying the victim, the finding of that much blood on his body, the matching of the blood group with the blood group of the victim, all those facts, the finding of the knife with him, all those facts together coupled with the incriminating facts in the admission had been complete the chain, and therefore he was convicted in this case. And therefore he was convicted in this case. अब इसको लिखिएगा आप. So write down. In this case, in the light of the other circumstantial evidences, the exculpatory part of the statement or admission of the accused was inadmissible, and therefore what remains is the inculpatory part. Full stop. The fact that the accused made the false conduct of not identifying the victim, and also that he was found to be washing the blood in the river, and the blood was too much of blood, which cannot be released by his simple cut in the hand, knife also was discovered from him, which in the doctor's opinion could have been the murder weapon. The finding of the injury on the left hand is suggesting of scuffle. स्कफल मतलब हाथापाई, जो हाथापाई होगी विक्टिम और एक्यूज के बीच में हुई होगी, लड़ाई झगड़ा. द फाइंडिंग ऑफ द स्कफल दैट ही मे हैव विद द विक्टिम, कॉमा, in the light of the above exculpatory part is rejected. That he may have had with the victim in the light of the above exculpatory part is rejected. Moreover, the name of Lal Mohan Sharma appears to be a fictitious name. Thus, name of the Lal Mohan Sharma जो उसने बताया था accused ने, that he was the person enters into the train, that name, the name of the Lal Mohan Sharma appears to be a fictitious name. Thus, out of this statement, What remains is the incriminating part, that he was present in the compartment with victim, and also that he knew the details of the crime. These admissions are admissible, and and coupled with other circumstantial evidences, they are sufficient to complete the chain of circumstantial evidences and to convict the accused. So this is how you have to separate the two parts of the sentence statement. अब मान लो circumstantial evidences strong नहीं होते उसके खिलाफ, तो आप exculpatory part को हटा नहीं पाते. सपोज लाल मोहन शर्मा मिल जाता, सपोज उसका इतना सारा ब्लड नहीं धोया होता, नहीं मिला होता, उस पर चाकू रिकवर नहीं हुआ होता, एक्सेट्रा एक्सेट्रा, तो फिर circumstantial evidence is weak against him, then you could not able to exclude the exculpatory statement. So that is how your approach to be. तो कन्फेशनल हो या एडमिशनल स्टेटमेंट हो, सबसे पहले आप देखोगे एक्सकल्पेशन और इनकल्पेशन क्या क्या हो रहा है उसमें, फिर देखोगे आप सर्कमस्टेंशियल एविडेंसेस क्या है, और फिर देखोगे उसके बेसिस पर इनमें से कौन सा झूठ है. एक पार्ट अगर झूठ है तो झूठ वाले को रिजेक्ट कर दोगे आप, अगर एक्सकल्पेटरी पार्ट आपको झूठ लगता है तो उसको एक्सक्लूड कर दोगे, और इनकल्पेटरी वाला सच है तो उसको आप इंक्लूड कर लोगे. अगर इफ नेदर ऑफ देम इज फाउंड टू बी फॉल्स, देन यू हैव टू एडमिट बोथ ऑफ देम, एंड इन दैट केस कन्विक्शन नहीं हो पाएगा. सो दैट्स इट फॉर दिस टॉपिक एंड दिस लेक्चर ऑल्सो. थैंक यू.